of contracts generally, decision-making process.
I think she disappeared.
Yeah, I got the live stream notice and then it got weird.
Hopefully she'll sign back on. You want to let her know that to sign back on?
Yeah, I am.
Or do you just want to take over arguing? It's
If the court would rather me take over the argument to save time.
I'm happy to wait, but usually people sign right back on if that happens.
Yeah, her computer or the sound wasn't working, and so then she went and got the other computer, and then I guess so. There may still be a problem, Judge. So let me, if the court will, I'll just finish where she was gonna. I don't have the documents queued up, but where she was going with that, Your Honor, is in the declaration. It talks about the day-to-day running of the company, and the next point to make with regard to this is in defendant's disclosure responses. Here she is. Come on in here. I'm going to yield to Ms. Kessinger if you're good with that. Sorry about that, Your Honor.
I apologize, Your Honor. Technology is not working in my favor today. But as I was noting on the declaration, Mr. Fowler, even in paragraph 10, just using that as an example, states that he doesn't have knowledge of any contracts that PSN has entered into or any litigation relating to those contracts. But we know that PSN as a company has been involved in several lawsuits just within the past 3 years. Just based on the lawsuits that we know of, at least 20 involving claims of breach of contract. And if we look at the disclosures that PSN has provided in this case as well, there's been no other individual identified as a representative of PSN services that would be able to provide testimony regarding other litigation PSN has been involved in. In fact, the only individual who's been identified as a representative of PSN affiliates is an individual, I believe, by the name of Ryan King, my apologies. But PSN affiliates, Your Honor, is not a defendant in this case. The named defendant is PSN Services. And again, there's been no individual identified as a representative of PSN Services aside from Mr. Fowler. On that same point, Your Honor, we're dealing with a few different entities in this case. PSN Services is the named defendant, but we're also aware of PSN affiliates and another group called PSN Group. Mr. Fowler is listed as the sole member and manager of all three of these entities, and there's been no other individual identified as a member of these three entities. In order for FinThrive to understand the relationship, if any, between these parties, we need Mr. Fowler's testimony to clarify that issue. For these reasons, Your Honor, we recommend that the court grant the motion to compel Mr. Fowler's deposition and overrule the motion for protective order.
Response?
Yes, Your Honor. Thank you. Jason Sanders on behalf of PSN Services. One thing I'd like to just start out with is that the statement that Mr. Fowler's representation that he has no knowledge and then no unique or superior knowledge is absolutely incorrect. He says he has no firsthand personal knowledge and no unique or superior knowledge. He doesn't say I have no knowledge. It's not disingenuous. It's not contradictory. You could absolutely have no specific firsthand personal knowledge, but have some knowledge based on being the CEO from your general counsel or other employees. So Mr. Fowler's declaration specifically in incredible detail explains that he does not have any firsthand personal knowledge and no superior or unique knowledge of basically almost anything the plaintiff has pled. I'd like to direct your attention to one of the cases we cited, In Re TMX Finance of Texas, Inc. The CEO in that case actually testified very similarly. Said, I don't have any firsthand personal knowledge of relevant facts concerning the subject matter of the above captioned lawsuit, including facts and allegations relating to, and then listed a plethora of the facts that were purportedly relevant in the case. After that, the CEO did say that that she did have knowledge of some facts relating to some of these issues by reason of her position as the CEO, but that was totally insufficient to demonstrate unique and unique knowledge, unique and superior knowledge. Another point, Your Honor, is it's not that whether the CEO has relevant or discoverable information. The Supreme Court made that very clear. In Ray Alcatel USA, the court, after acknowledging that the executive may have some discoverable information, the court went on to say, but the first Crown Central guideline requires more. It requires that the person to be deposed arguably have unique or superior knowledge of discoverable information. This requirement is not satisfied by merely showing that a high-level executive has some knowledge of discoverable information. If some knowledge were enough, the Apex deposition guidelines would be meaningless. They would be virtually indistinguishable from the scope of general discovery. Although Crown Central did not elaborate on what character of knowledge makes it unique or superior, there must be some showing beyond mere relevance, such as evidence that a high-level executive is the only person with personal knowledge of the information sought, or that the executive arguably possesses relevant knowledge greater in quality or quantity than other available sources. And again, that's In Re Alcatel USA Inc. 11 Southwest 3rd 173. And I was quotes from page 179.
So, Mr. Sanders, whose deposition should she take then?
Corporate representative. In fact, Your Honor, when Mr. Palmer reached out to me asking for Jordan's deposition, or Mr. Fowler's deposition, excuse me, I went back to my client, came back and said, look, he didn't sign this agreement. He didn't negotiate this agreement. He has no unique or I always forget or superior knowledge. And there was no report telling me that what he had. And I said, so if you want to provide topics, I'll get you a corporate rep. They can get what the courts made clear that
who did negotiate and sign this contract?
Let me see. I don't know offhand who negotiated it. I may have an email or two on that, but needless to say, my client for me was not Mr. Fowler, and he did not sign it either.
Is that correct, Mr. Palmer?
Yes, I believe that's correct. Mr. Fowler did not sign the agreement.
It was signed by Ryan King, who's not even an employee of PSN Services.
And Your Honor, that was a typo on our part, I think, when we put PSN Services in our disclosures. And when I object to that, that isn't before the court, our disclosures. But we did identify Ryan King as a corporate rep on our disclosures, but I think it was a typo by saying PSN Affiliates. PSN Affiliates, I think, is an affiliated company of PSN Services. PSN Services is an entity that provides management and administrative services to affiliated entities, I guess, of folks in kind of the PSN network, so to speak.
But Your Honor, if I may, there's no other person we've identified with PSN Services other than Mr. Fowler. And PSN Services is the named defendant in this lawsuit. There is a Mr. King who's listed under PSN Affiliates, but on their website, but there's no one else we've identified related to PSN Services other than Mr. Fowler.
But why wouldn't you take the deposition first of the person who actually negotiated and signed the contract?
Because, Your Honor, in this case, and like many others PSN's been involved in, they sign these contracts, it appears, over the last 3 years. There's over 20 lawsuits, and it almost seems like it's a pattern of practice where they just want to take in the money, get the services, and then they don't pay for it. And so in terms of this particular contract, I believe that's later on, but we have an interest to find out, is PSN Services even the correct party to this case? The one, because there are so many other entities, there are so many other.
What does it say on the, who's the contract with?
PSN Services, and in the statement of works, there is the 70 other hospitals or so. I use 70, but it's a lot, where our services were to be implemented at that have relationships with these other PSN entities. And Mr. Fowler, as the really he's the one running the show here. he has knowledge of all those relationships, of all these lawsuits, and as to how PSN services fits into that. And so my goal was to understand that, and then we can kind of drill down on the contract details themselves. But it was a clear breach of the contract. So, you know,
what I typically do in these kind of cases, obviously I follow the law. I think the best way to approach that, given the current state of the law, is to allow you to take the deposition of kind of the frontline person first. If it turns out they don't have the information you actually need and you need to go higher up the chain, doesn't sound like the chain is very long. How big is this company?
Your Honor, well, but Mr. Palmer seems to know a lot about the company, which I would object to all that as pure conjecture that Jordan knows. There's no evidence they provided that Jordan knows, Mr. Fowler knows any of these things that Mr. Palmer is testifying about himself. No evidence in the record on that. This is all pure conjecture. And I have multiple clients that are sued way more than 20 times a year. That's totally irrelevant. We got to remember, there's one claim that was asserted in this case, Your Honor, is breach of contract. And in our first year of law school, we all learned what the elements of that are: the existence of a contract, performance by the plaintiff, breach by the defendant, and damages. The CEO being deposed on that, come on. This is a a bullying, harassing tactic. Mr. Fowler is not a necessary deponent here whatsoever, and they know it.
I'm going to go ahead and I guess grant the motion to quash. I am going to allow you to take the deposition of the person who actually negotiated this contract and signed the contract. And if that point, after taking that deposition, you want to bring this back, so just kind of deny this without prejudice, the refiling it, you may be able to take the CEO's deposition, but I don't typically allow the CEO's deposition right off the bat. So does that ruling make sense?
It does, Your Honor.
Yes, Your Honor.
All right, give me an order on that. Indicate that was heard on November 6th, 2023. Email my court coordinator and email that by the end of the day tomorrow. Okay?
And,
Yes,
and Your Honor, for purposes of the order, can we put in there that I guess it'd be Mr. King's deposition is ordered in the next 45 days?
That's fine.
Okay, thank you, Your Honor.
He's the person who negotiated the contract and signed it.
I'm pretty sure, and I'll agree. We'll double check that and put that.
Whoever the person is, I want to make whoever the person that negotiated and signed the contract, you can take their deposition.
Okay.
Yeah, sure. My only issue with 45 days, it shouldn't be a problem, but we're coming into the holiday season. So I would hope that Mr. Palmer would work with us on dates, given Thanksgiving's coming up and the other December holidays.
45 days. I will say 45 days is more than I usually give. So 45 is fine.
Oh, thank you. Thank you, Your Honor. Thank you, counsel.
That'll take you all the way up to Christmas. So, all right, guys, give me an order on that. It's by this Wednesday, end of the day on Wednesday. Make sure it says again that it was heard on November 6th, 2023. Share it with opposing counsel. Make it clean. Don't get a lot of extra stuff into it. And we'll anything else you guys want to chat about?
No, Your Honor. I guess we don't have a scheduling order. Is that something the court, if we submitted a request for one?
But let me double check that. Let's see. You are correct. You just had an answer filed. Is this a level 2 or level 3 case?
Level 3.
All right. Rhonda, are you there?
Yes, Judge, I'm here.
So we can set an official scheduling conference, or we can just pick a trial setting right now, whichever you prefer.
I'm fine with the trial setting, Your Honor.
When do you guys want to set this for trial? I don't know how much discovery you need.
November, I mean, as Mr. Sanders said, it's a breach of contract case. So I would think if we're getting this depo in the next 45 days, I mean, we'd be more than ready by the spring, end of spring.
Yeah, I think that's a little aggressive.
Yeah, I agree.
I would suggest that Mr. Palmer and I confer and submit a agreed schedule or agreed trial date. And if we can't agree, we can file.
You've got two choices the way I do it. You can I'll either say just schedule this for a scheduling conference, or you pick a date right now. So do you want me to, and just I'll say this: if you get me an agreed scheduling order, before then you don't need to go to the scheduling conference. But if you don't, I want to have something on the books. So what do you prefer?
Your Honor, I'll defer to Mr. Sanders. I mean, I feel like I'm pretty easy to work with, so I have no doubt we can come up with some dates.
I agree with that, but I think it'd be a little rush for me. We're kind of a small firm to pick a trial date right now. I'd like to.
That's no problem. We will go ahead and why don't we set this for a scheduling conference? How long will it take you to confer with your client?
I would think we could get that done this week. I mean, yeah.
What if we set the scheduling conference on the 20th? Will that give you enough time?
Yeah, I'm in Houston for a mediation on the 20th, but that would give me plenty of time.
What time is your mediation?
I think it's an all-day mediation in Houston. But I mean, if you're going to set it by Zoom, Your Honor, I'm sure I could absolutely figure out a way to make that happen.
How about at 7 o'clock? Sorry, not 7 o'clock. 10 o'clock on the 20th.
Yes, that would be good. That would work by
And
Zoom,
again,
right?
By Zoom, and if you get something worked out before then, just let me know.
Does the court have any guidelines on a trial date when the court would like to see it set? And Mr. Sanders and I can work from there.
I will say this, that typically on these kind of cases, we're going to set it at least a year out. But
Okay.
a year from when the answer was filed, so that would be sometime next summer, I guess. So,
Your Honor, I can put something together, and I'm sure Mr. Sanders and I can submit something before that 20th date.
okay.
Thank you for holding. This is Rhonda with the 6th District Court. Can I help you?
Rhonda, you're on. Okay. Sorry, she just had to take a call. Rhonda, go ahead and set this for scheduling conference, okay?
I'm sorry, Judge, go ahead and set it for,
A
scheduling
scheduling conference for the 20th at 10 o'clock
okay,
on Zoom, obviously.
got it.
All right, guys, have a great rest of your day and just try to get that in and get that order in as well, okay?
You too, Judge. We will. Appreciate
Thank
you.
you, counsel. Take care.
All right,
Okay.
guys, I'm sorry, I'm gonna have to take a break. Oh, you guys can go, but the next
Thank you,
case,
Your Honor.
we just got a verdict, so